What theory did John Deaton put forward? How relevant is it? How will this theory affect the trial? We will answer these questions in today's video. With the completion of the highly known Securities and Exchange Commission (SEC) lawsuit against blockchain startup Ripple presumably inching closer, a pro-XRP legal expert has offered his thoughts on the case's likely outcomes. Likewise, in a March 10 Twitter thread, Scott Chamberlain, a former lawyer and co-founder of the permissionless Layer 2 platform Evernode, XRP, enumerated 5 probable possibilities for the lawsuit's resolution, including summary judgments, the prospect of settlement, and following lawsuits. In particular, the legal expert said that the regulator did not have anything near the evidence to demonstrate they intentionally or carelessly marketed an unregistered investment in the summary judgment phase involving Ripple CEO Brad Garlinghouse and co-founder Chris Larsen. About Ripple's summary judgment on foreign sales, Chamberlain noted that Ripple's sales of XRP on overseas exchanges are not within the court's jurisdiction, adding that an entirely new precedent would be formed to declare those domestic transactions closed in the U.S. Moreover, Chamberlain emphasized that this complaint might lead to a limited case that investigates whether any of Ripple's sales of the XRP cryptocurrency in the United States constituted an unregistered investment contract. In other news, New York Attorney General Letitia James filed a lawsuit against KuCoin, accusing the cryptocurrency exchange of unlawfully functioning as a securities and commodities broker, dealer without registering with the state, as Finbold reported. Scott Chamberlain, a former lawyer and co-founder of Evernode, a proposed Layer 2 smart contract technology for the XRP ledger, has published his 5 predictions for the result of the SEC action against Ripple. To begin, the co-founder of Evernode thinks the SEC will lose its case against Ripple executives Brad Garlinghouse and Chris Larsen. Remember that the SEC had identified the executives in their lawsuit against Ripple, accusing them of aiding and abetting the offer and sale of unregistered securities, XRP. According to crypto law, founder attorney John E. Deaton, the SEC must demonstrate that the executives were reckless in failing to recognize that XRP was a security. The SEC, according to Chamberlain, lacks the evidence to substantiate this. Second, Chamberlain believes the court will rule that Ripple's offshore sales of XRP fall beyond the scope of the court's authority. The former attorney said that classifying them as transactions done in the United States would establish a new precedent. In his last forecast, the former lawyer claims that the only question is whether any Ripple XRP sales in the United States contained an unregistered investment contract. Because of his second and third forecasts, Chamberlain anticipates that the SEC will seek a settlement. According to the former lawyer, the SEC overlooked the fact that the majority of Ripple's XRP sales happened offshore. With the lengthy legal struggle coming to a conclusion, at least at the district level, it is predictable that speculation about its fate has reached fever pitch. Chamberlain's projections, for the most part, agree with Deaton's prior forecasts and analysis. Significantly, the attorney projected that there would be no out-of-court settlement until after a summary judgment finding to delay a prospective trial or appeal. Moreover, the crypto law creator has said that the SEC's only potential triumph would be if Ripple traded securities between 2013 and 2017. As a result, he thinks there will be no disgorgement or injunction on XRP sales, but Ripple may be required to pay a fine. The cryptocurrency world is anticipating the summary decision in the legal action between Ripple and the Securities and Exchange Commission, with the ruling expected by the end of March. In the most recent update, United States lawyer Jeremy Hogan stated in a tweet on March 9 that presiding judge Annalisa Torres may have already ruled whether XRP is a security. Hogan, a pro-XRP lawyer, reached this conclusion after noting that the judge mentioned the securities law case Marine Bank v. Weaver at least 3 times in her most recent judgment when describing the viewpoint of XRP holders who purchased the coin. Hogan also released an extract from the lawsuit, wondering if what was offered was commonly recognized as a security. The court addressed the Marine Bank v. Weaver case at least 3 times in her latest order when addressing what a reasonable XR purchaser thought when they purchased XRP issue. The lawyer's allegation comes after Judge Torres issued a 57-page ruling on the dollar bear applications made by both parties to exclude expert evidence from the summary judgment. According to the verdict, neither Ripple nor the SEC are the winners, since the court approved and refused elements of each party's request. Judge Torres rejected the SEC's top expert witness, Patrick Doody, who was entrusted with examining XRP purchasers' expectations. Nonetheless, Ripple's experts on the distinctions between Ripple's contracts and those in the Howard case, the tax treatment of XRP, the accounting treatment of XRP, and currency experts on XRP were all permitted to speak on the record. Despite the absence of a clear winner in the Daubert motion's judgment, Ripple's chief legal officer Stuart Alderodi stated that the conclusion was in favor of the payment service and that he was confident in the case. As we have indicated throughout, we have always been confident about our case, and with each judgment, we have become even more so, Alderodi added. At the same time, pro-XRP lawyer John Deaton feels the SEC made a big mistake in identifying Ripple executives Brad Garlinghouse and Chris Larson in its enforcement action against the business. According to Deaton, the SEC should have focused only on Ripple, the firm that issued XRP, rather than prosecuting people who were not directly responsible for the alleged securities breaches. Deaton first claimed that the judge in the case criticized SEC attorneys of putting their interests ahead of enforcing the law. The lawyer questioned the SEC's capacity to properly enforce the law if its agents refused to do so. According to Finbold, Scott Chamberlain, a former lawyer and co-founder of the permissionless Layer 2 platform Evernote XRP, predicted that the lawsuit will most likely have 5 outcomes. Chamberlain predicts that the case will be settled, establishing precedence on the classification of XRP as a security and the court's authority over sales made outside. Earlier, Ripple sent a statement in support of their fair notice defense, citing a recent Supreme Court decision. The submission was made in response to a judgment that limited the U.S. government's authority to levy fines on us taxpayers who do not reveal their offshore bank accounts. Ripple stressed the need of federal legislation creating clear limits on what behaviors are forbidden, emphasizing the necessity for regulatory certainty in the cryptocurrency business. The price of XRP skyrocketed today as investors gained optimism that the Ripple v. SEC litigation would most likely be resolved within the next few weeks. This indicates that we may finally be able to see an end to the legal stalemate we've been in. The most essential thing to note is that it seems as if Ripple's prospects of winning the lawsuit are increasing with each passing day. The long-running issue that Ripple has been having with the Securities and Exchange Commission, SEC, of the United States might be resolved within the next few weeks. This upbeat outlook is a direct result of U.S. District Judge Annalisa Torres' decision, which came after great anticipation to rule on the parties' applications to exclude expert evidence from the pending action. The XRP army greeted the decision with cheers and applause once it was announced. On Twitter, a devoted user of XRP who goes by the online alias Learshit made the insightful observation that a tight victory for Ripple on the basis of strictly mathematical calculations. Almost 246,000 people are following John E. Deaton on Twitter, where he shared the specifics of the judgment with them. Deaton is the creator of the legal news source Cryptolaw and represents clients who own XRP. In response to his message, a user on Twitter posed the question of whether the most recent event may perhaps provide light on the amount of time that remains until we get the summary decision. With a cheery sense of optimism, Deaton made the following observation: "I sincerely doubt that we will see a major delay from here. That may happen today, or it might happen in a few weeks." The Securities and Exchange Commission, SEC, filed a complaint against Ripple in December 2020, alleging that the company unlawfully marketed unregistered securities totaling $1.03 billion worth of its XRP coin. From its inception, the blockchain payment startup with headquarters in San Francisco has vigorously refuted the notion, maintaining that XRP does not qualify as an investment contract according to the famed Howey test. Ripple's position in this legal dispute seems to be strengthening as a result of recent favorable events in the judicial system. But in the event that the SEC were to emerge victorious in this lawsuit, there would be a highly unfavorable legal precedent for the whole of the cryptocurrency industry. For this reason, investors, developers, and stockholders alike have been watching the case intently over the last 2 years. Fred Rispoli, an attorney, agrees with Deaton's viewpoint. Rispoli expressed his belief that the most recent decision rendered by Judge Torres is evidence that a summary judgment is very near. He claims that it is possible for the judgment to be delivered as soon as this month. Rispoli summed up the situation by saying, "So, summary judgment is either going to come out anytime or J. Torres is going to drop this one first to entice the parties into settlement